Good afternoon. Welcome to the 5th District Court of Appeal. We have one case on our docket this afternoon. That is case 23-1513, Atlantic Candy Company et al. Versus Yowie North America et al. My name is Scott Makar. With us also is Judge Lambert and Judge Heisnagel. Because there's a cross appeal and there's 20 minutes allocated per side, I'll ask each of you as you begin your arguments to reserve whatever time you'd like to reserve for rebuttal. This is a continued oral argument. We appreciate the parties doing this via Zoom to basically keep down the costs of travel and so forth. And also, if you'd identify yourselves at this time, I see we have, just go ahead. If you identify yourselves for the record, both counsel.
Good afternoon, Dimitri Pedoves for the appellants and cross appellees.
Okay, thank you.
Good afternoon, Judge. Josh Dickinson for Yowie North America et al.
Okay, very good. You'll see that on the screen there's a light that has 20 minutes up there. Keep an eye on it. If you reserve 5 minutes for rebuttal, at that time a yellow light will come on and it'll start ticking down to 4:59, 4:58, and so forth. Sometimes people don't catch the light because sometimes the light doesn't come across as well over the internet. And with that, we'll hear oral argument.
Good afternoon, and may it please the court. My name is Dimitri Pedoves, and I represent the appellants / cross appellees Whetstone Industries Inc. and Henry Whetstone Jr. I'd like to reserve 5 minutes for rebuttal, please.
Thank you.
So this case involves two contracts, a license agreement and a manufacturing agreement. And the primary issue before this court is whether Yowie improperly terminated those contracts. I'd like to start with the license.
Counsel, is the term minimum fees, it's not defined, right, in the contract?
That's correct.
Is it the same, does it have the same meaning as the term minimum fees as used in Section 1? Section 5 is as an important provision, I think, for your argument. It uses the term minimum fees. Section 1 also does. Do those two terms, do they mean the same thing, or does somehow Section 1 mean something different than Section 5?
I think it helps to explain how those two provisions work together. And I think sections 4 and 5 are the real minimum fees. And what Section 1 was, if they ended up producing more units, so if they ended up producing more than what the minimum fees were, that's when Section 1 would kick in and they would end up paying more.
Okay. Counsel, where does it say that?
That is not in the contract written, but that is, the parties agreed that's how it operated.
Okay. But it's, you agree that's not anywhere in the written contract?
Yes.
Okay, when we interpret a contract, the Supreme Court's told us we apply the supremacy of the text principle, correct?
Correct.
So don't we need to have some text in the agreement in order for you to prevail?
Yes, and I think there is some text, especially when you consider what the Supreme Court has told us in the Connage case.
But let's start, what's the text that says, and I mean, you've already said there is no text, but I'm going to give you another chance. Maybe there is text and maybe you spoke too soon, but where's the text that says that the Section 1 payment is only once you hit over the minimum fees somehow?
There's no text that says that, but it is my understanding that's undisputed. That's how the parties operated this contract. That the fees under Section 1 would go towards the minimum fee, and if they exceeded the minimum, there would be extra payments. And if they were less than the minimum, they would still have to pay the minimum.
If they want, well, and then that we get to the actual issue in this appeal, which is, did they have to do that or not?
Right.
Okay.
That's how the trial court interpreted it.
I guess my initial question here was I was trying, it sounds like you do agree that the term minimum fee in Section 1 is the same minimum fee that appears in Section 5.
I guess so. I do think sections 4 and 5 are the real minimums, because Section 1 could end up being more, but they're so interrelated. It's kind of hard to separate them.
No, absolutely. I agree with that. I'm just asking you for the term minimum fees. I'm just
Yeah.
trying to nail down the meaning of minimum fee, and I'm asking you, is that the same, does that term mean the same thing in section 5 as it does section 1? Or is there somehow a completely different meaning to the term minimum fees?
I think they all work together. So I think in that sense, they do mean the same thing. When you have to consider it all together. You can't view these terms in isolation. And that's what I was trying to
Okay,
talk
counsel,
about.
could I ask a question to clarify there? As I read the contract, you have these minimum fees under section 1. That's the basic royalty that's paid to an owner of intellectual property. But then sections 4 and 5 are quite different because they talk about the minimum fees for exclusive versus non-exclusive situations. So my initial reading of the contract was that here are the minimum fees, the fees you have to pay percentage-wise each year on the sales or whatever the dollar value is. But in no case, or in any case, if you want exclusivity of your product in the United States, you have to pay the following amounts. That's section 4. But if you want the non-exclusive right, meaning I can compete against you, Whetstone can put out its competing product and not have exclusivity with Yowie, then those are basically minimum fees that have to be paid overall.
I think that's correct.
So if there's no sales in year 3, say in 2015, your position would be if it's exclusive, if the other side has opted to have exclusive rights, they have to pay you in 2015 1.5 million. But if they want non-exclusive, it's 700,000.
Yes, although I think the numbers may have changed. I'm not sure if you're reading from the amendment.
Right. Right. There's a renegotiation a year or so later. Right.
Yeah.
But the concept is that
Yes.
on track?
Right. So
And counsel, just so I'm clear, that sounds all, I think I'm tracking everything that's being said so far, but sticking with 2015 and the original numbers, the 700,000. If Yowie had ordered $700,000 worth of product and sold it, and so there were 700, they owed 700,000 under section 1, then is it your position that they would have met the non-exclusive minimum from section 5?
correct.
Okay, all right.
So that's how they did it in previous years.
So it wasn't that they had to sell a bunch of stuff and also pay an additional 700, right?
Correct.
Okay.
Correct. And that's what they did in the past. For example, I think in 2014 they sold like a few thousand. There was that much royalties, so that was acted as a credit towards the minimum fee. So that's how the parties have operated it. And I know there's no language that says they had to pay those minimum fees, even if they didn't sell any product. But I think it is important to view the contract as a whole.
Well, counsel, if I could cut to the chase on that, your position is that this was a contract, the two contracts together formed a deal, and that it was exclusively between these parties to manufacture and distribute this particular product, and that the term of the contract is what it is, meaning you cannot get out of this contract unless there's a default, right? Under section early termination. Early termination only occurs if there's a default and it's not remedied.
That's
Otherwise,
correct.
you're stuck in the relationship for the term of the contract. That's your position.
Yeah, the manufacturing agreement had a termination for convenience clause, but that required a year, and it couldn't be terminated before 2027 in any event. And as you said, the license agreement did not have a termination for convenience clause.
Yeah, that's what I was looking at, was the licensing agreement.
So that's really what the parties negotiated. This wasn't a contract that needed to be renewed on an annual basis. They expressly agreed that it would have this term, that it could only be terminated under these conditions. And then, despite the fact that there was no breach from Mr. Whetstone or Whetstone Industries, Inc., Yowie effectively terminated the contract.
Counsel, look, first of all, let me commend you for being very candid with the court. that doesn't maybe always happen as much as we'd like. And you've really allowed us to get to the core of the issue. And I think that's important for everybody's client, for the court. It makes a lot of sense to just get to the core of the issue. You've said there's no words in the contract that required the non-exclusivity, right? And I think that's right. I've scoured the contracts. I can't find that either. So I guess my question to you is, let's get into the nitty-gritty of how, if without any words at all to say, without any words to hang your hat on, right? How do we take the supremacy of the text principle, emphasis being on text, and say, well, here there is a requirement of paying the of meeting the non-exclusivity threshold, if you will.
So when we're interpreting text, the Supreme Court has told us we have to exhaust all the tools in the toolbox. So that includes all the canons of construction. And one of them is that we don't read provisions to be meaningless. And here, if we accept Yowie's position, the trial court's position, these termination provisions and the expiration date of the contract become meaningless. What's the point of having a contract that you can't terminate and that has a fixed date if you can just stop producing under the contract and not pay any fees?
Well, I think
Well, they're not, in that case, they would, right? They wouldn't be permitted to produce the product anymore.
Right, but the terms would be meaningless. Why?
Well, no, I mean, look, a big part of these contracts is licensing the use of the patents, correct?
Yes.
I mean, wouldn't you say that might be the biggest part of the contract?
I think that's equal with the manufacturing.
So 50-50, the licensing and the manufacturing. So half of the contract is the license to use the patents. If they don't pay the non-exclusivity, if they don't reach that threshold, they don't get to produce under the patents anymore. That seems like I mean, how is that not a significant consequence?
It definitely is, but the parties didn't say, Yowie, you can choose whether to pay these. They said, Yowie, these are the fees, and this contract doesn't expire until this date, and you can't terminate it. So just as Mr. Whetstone was boxed in and couldn't go and make an exclusive agreement with someone else, Yowie was also boxed in, and it couldn't terminate this absent a breach.
But you keep saying terminate, and I guess that's what I'm saying is I just don't. Here's the thing: if Yowie didn't want to meet the non-exclusivity threshold, right? There's nothing, and they've already conceded, and you're right. There's absolutely nothing in the contract to expressly say that they had to. But if they wanted to, if they just decided they wanted to walk away, then they would have no right to produce under the patents for, by the way, it looks to me like, would you agree, they wouldn't even be able to produce the products even after the patents expired for a while, right?
So they claim that they made their own patent.
No. Let's not get into all that yet.
Yeah.
I'm just saying, in a world where they want to use the Whetstone patents, and then they decide that for whatever reason they're not going to produce under the patents anymore, okay? They would be unable then to produce under the patents for years after the patents expired. Yes or no?
Yes, because the way the contract's defined, it includes Mr. Whetstone's technology. So it's not just the patents. He had a lot of other intellectual property he was giving as far as developing the manufacturing line and so forth.
And I mean, it's the patents and the technology. They essentially would be locked out. And by the way, and this is the important part, even after the patents expire, correct?
Yes.
Okay.
But I think there's a problem with that interpretation, with reading it as Yowie having this option, because as I argued in my brief, in the initial brief, to have an option, there needs to be consideration for that option. So Yowie needs to have either had some detriment, or Mr. Whetstone needs to have gotten some benefit to keep that option open, to give Yowie the right to exercise that option. And I cited the Polk case, for example, where there's a real estate contract and there's a.
Well, counsel, if I could, just to cut to the chase. I think there's a couple things, but for the first one that comes to mind is the thing I just said, which is that how is giving up what the right to produce under the patent, even after the patents have expired? In other words, Whetstone got a benefit here too. Yowie says, hey, look, we're not even going to be allowed to, even after the patents expire, right?
Oh, okay, I understand.
We
what you're saying now.
we don't get to use the patents. Everybody else might get to use them because the patents have expired, but we're not going to get to. I mean, I think there's other potential consideration, but how is that not consideration?
Because that's not something they gave up. That's something they didn't have to begin with. That's Mr. Whetstone
so
has the patents.
Maybe I don't understand. So after the patents expired, what are the ramifications of the patent expiring?
After the patents expire, I mean, they couldn't be sued for patent infringement.
Right. So if Yowie said, hey, we won't even be able to use the patents even after they expire, how is Yowie not giving something up?
Well, because they don't inherently have a right to use this. This is Mr. Whetstone giving them that right.
Can they use it after the patents expire? I guess that's the question I was asking a minute ago.
Okay, and I think that I may have been confused. I don't think this somehow precludes them in that sense, that after they expire, if you read the language of the contract, it just says Mr. Whetstone would be allowed to license it to other people. It doesn't say Yowie won't be allowed to do X, Y, or Z.
It says Yowie shall immediately cease manufacturing all products. That's what the contract says.
Yes, but the way products is defined is it's under the patent. So
right, they would immediately have to cease manufacturing all products that are produced under the patent. By the way, as I read it, that would extend beyond even the expiration of the patents, as I think we've established. So why is that not consideration?
Because that's something they only get once they exercise the option. So they start from zero, right? They don't have any rights.
Hold on. If there was never an agreement, between Yowie and Whetstone, when could Yowie have started to legally use the patents? If there was never an agreement.
Only if Mr. Whetstone gave him a right, or when the patents expired.
When the patents expire, that's the key. So if Yowie gave up the right to use those patents upon expiration for a period of time, would that be consideration?
I guess it would, but I don't think that they've done that here. Because of the way products is defined as being used under the patents, and then at the time the patents expired, it would be nonsensical to say that they were being produced under the patents. So
I mean, the agreement continues on to, is it 2027, or was that amended?
Yes.
Okay. And the earliest it can be terminated for convenience is when's the amended date?
The license
25?
agreement was not amended, so can't be terminated for convenience.
Before what?
Before, I believe, the expiration date, 2027. Yes.
Okay. So the agreement would continue, right, until that time, which is many years after the patents expire. Do you agree?
Yes.
Okay.
I'd like to reserve any remaining time I have.
Counsel, I'm going to give each side an additional 5 minutes. So you're essentially not quite to your rebuttal time if you reserve 5 minutes. Is there any patent litigation ongoing?
I'm not sure, but I don't think so, but I'm not sure. I'm sorry.
Okay. All right. And I just want to focus in. It seemed to me that probably your strongest argument is that, at least under the license agreement, that the early termination clause, section 14, basically gives the strongest indication that this is an agreement in which the parties are bound for the length of the agreement, and that there's a certain minimum amount of money that has to be paid to your client during that time period. Because the only basis to terminate early is nowhere in here does it say that that the other side can walk away, right?
Right,
There's no text that says that the other side can just walk away from the agreement without any consequence. So,
right.
So the point of the section 14 is to say either party may terminate, but it's only if there's a breach.
Correct.
Okay. So you're arguing that, right?
That's the
Right.
essence of my argument is you
Okay.
have these termination clauses.
But counsel,
And-
doesn't that beg the question? Did they violate section 5? That, I mean, we still go back to section 5, right? That's the breach,
Yeah,
right?
you do have to look at section 5 because that's, the trial court said, yeah, they could just walk away, pay nothing, and no, they didn't terminate, they just didn't have any obligations.
But at the end of the day, we've got to figure out what section 5 means. That's
To do that, you have to look at the whole contract,
yes.
including the termination clause, including the expiration date, including the fact that they set forth fees specifically for multiple years. All of that.
If Yowie said, hey, we're not going to do non-exclusivity, we're not going to meet that threshold. And let's say they were just under the threshold. Let's say they were in 2015, let's say they were at, 600 instead of 700,000. Okay. And they said, hey, we're not going to pay the extra 100,000. So we're not going to have non-exclusivity. The contract says they have to cease manufacturing all products, right? And that's patented, the Whetstone patent products.
Yeah.
How are they not then closed out until 2027 from ever using the patent again, which is what, 8 years after the patent expires?
So I point your honor to one of the whereas clauses.
Okay.
To page 2198 of the record. And that's where the term the product is defined. And Yowie has consistently taken the position that in order for it to be the product, it has to be produced under the patent. So once the patent is expired, a product, it would no longer meet that definition. It could no longer be produced under the patent. So
I'm not sure. That seems like a little bit of a leap, but I'll have to think about that.
Counsel,
Okay.
You're into your rebuttal time. Would you like to continue?
I'd like to reserve it, please.
All right, thank you. All right, Mr. Dickinson, you've got 25 minutes. Would you like to reserve any of that time?
3 minutes, Your Honor.
All right, thank you. Proceed, please.
Thank you, Your Honor. In my initial time, I'd like to talk about I'm hoping to talk about both the patent agreement and the manufacturing agreement. Judge Maker, just to answer your question, there is no ongoing patent litigation and there never has been any patent infringement litigation. So I just wanted to make that point clear since you asked the question. What's important I'm just going to pick up where y'all left off, which is with respect to the patent agreement and the key provisions, which are section 4 and section 5. What is key to look at there is that there are rights and remedies that are established in each phase of the contract. And in section 4, if you pay a higher sum of money, you get exclusive use of the patent. So what does Yowie get? They get exclusive use of the patent. What does Whetstone get? They get a premium amount of money. You move down to section 5, you pay a little bit less money, you get a non-exclusive use out of it. So Yowie gets non-exclusive use of the patent. Whetstone still gets money, but less money. But then Whetstone also has the use to go out and license that patent to anybody else that he wants to. The key here is the last paragraph of section 5, which spells out the rights and remedies if Yowie pays neither. The contract expressly provides and contemplates that Yowie would end up not paying the non-exclusive fee. It reads, if any of the above minimum fees are not paid by December 31st of any year, then Whetstone shall have the right at his sole discretion to immediately terminate this agreement, in which case Yowie shall immediately cease manufacturing all products. So what does Yowie get in that circumstance? It doesn't have to pay the money. Doesn't have to pay the minimum.
Hold on. When I read that to say, if your client doesn't make these above minimum payments, they can terminate the agreement and sue you in contract for not providing these fees. Why is that not?
I don't read anywhere in there that the provision states that they would have the remedy of being able to sue us for breach. And matter of fact, there's nowhere in here that requires us to pay that minimum. It uses the terms if. not when a payment is made. And it uses the term right, not obligation, to make these payments. And that's key, Your Honor. If they wanted the express right to be able to sue us for breaching for not paying either of those, they could have easily written that into the contract, but they didn't choose to do that. Instead, what they negotiated was a one fee for an exclusive relationship, one fee for a non-exclusive relationship, and then if there was no payment, then the remedy is expressly stated in there that they have the right to terminate the agreement if they'd like to.
Counsel, if it was how Whetstone argues, wouldn't it say Section 4, exclusive right, you pay these, you get to these thresholds? Section 5, if you don't get to the thresholds in Section 4 for exclusivity, you shall pay X.
Correct. That's what's missing. And I believe we put that in the brief, that this was even, if Whetstone wanted the contract to be enforced that way, they needed to add like 16 words, which is, if you don't pay the exclusive amount, you shall pay the non-exclusive amount. But that's just not what the contract says. And the parties negotiated for these rights and remedies. And, with respect, it's not this court's responsibility to rewrite the
counsel,
contract, because
here's another way
here's
another way it could have been said, I think. I mean, wouldn't you agree that they would be correct if the second part of Section 5 said, if Yowie violates its obligation to pay the minimum fees, then yada, 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 yada.
Correct. That would have been another way. I think the point you're making, Your Honor, is that this was easy to include in the contract, but it's just not there.
Having drafted dozens of these kind of agreements in my prior career, and having done litigation in the franchise forum, that's typically not done. Typically, you have a remedies provision like you have at the early termination remedies, Section 14, where it says, in addition to terminating the agreement, the non-breaching party may pursue any and all remedies to which he may be entitled at law and equity and so forth due to the breach of the other party. So there's where the remedy is. He gets to pursue a breach of contract action against your client if your client fails to perform. And that's what this case is all about, right?
Well, Your Honor, with respect, before you ever get to that point, you have to point to where we breached the contract. And if a clear reading of Section 4 and 5 does not mandate that we pay either one of those fees. As Judge Osnagel just said, there were ways to draft it so that it was mandatory. And then we'd be in a situation where we'd be in breach for not making that payment. But it's worded in a permissive manner and has an express provision that says that if we don't pay the minimum non-exclusive fee, here's the remedy. There's actually a remedy specifically provided for. He has the sole discretion to terminate the contract, and he has the ability to prohibit us from manufacturing any further products with his patent. That's his remedy. It's set forth expressly in the agreement.
Well, why, as I read it, I look at Section 4 or Section 5, it says essentially your client has the right to either have exclusive rights or non-exclusive rights. If you choose to not have non-exclusive rights, you can do that, provided the following minimum fees are paid. So in other words, if you have to have one or the other, you can't just opt out.
And Judge, with respect, I disagree with that reading.
Okay, well then follow me on that. Let's say I read it that way. Let's say Judge Eisenhower reads it a different way. It sounds to me like it's an ambiguous contract. It's not clear on its face because reasonable mind can read it differently. You took the position in the trial court that it's so clear we're not going to put on any evidence. Your opening statement below was, hey, Your Honor, we're not going to put on any evidence about the intent of the parties and so forth, the practice and so on. We're just relying on the contract itself. If, given the record that we have, if there is ambiguity in the contract and the trial judge ruled the way he did, couldn't you say that there needs to be a consideration of other evidence, the testimony and intent and practices of the parties?
Judge, my response to that would be, we're the defendant. We didn't bear the burden of proof. So it wasn't our obligation to come in and provide evidence, parole evidence as to what the intent of the parties were. The plaintiffs were never prohibited from providing that evidence. There was no motions in limine and there was no rulings from the court that prohibited the plaintiff in any way from providing parole evidence. They just didn't do it. So I don't believe that the appropriate remedy would be to remand it and ask that they put on that evidence that they were perfectly able to put on at the trial and for whatever reason chose not to.
Well, here's my question is, if there's ambiguity here, just assume there's ambiguity. I know that's not your position. Then wouldn't the position that this court, we'd have to look at the record as a whole and decide if it's ambiguous, and we look at it de novo and we say, given the ambiguity, it was fair to consider the evidence, the testimony of Mr. Whetstone and so forth. Would that, and I think I know what your answer would be. I think, you'd say, well, nonetheless, Your Honor, it's still an affirmance. The trial judge still got it correct.
Correct.
And that's because none of the other evidence in the record would suggest the type of relationship that Whetstone is suggesting.
Well, Your Honor, at the end of the day, I don't believe that the record reflects any particular parole evidence as to the meaning of this provision of the contract. For instance, Mr. Whetstone didn't take the stand and say, when I was drafting this back in 2012 time period, this is what I intended, and this is what Yowie's representative said to me. Here are emails that establish that. None of that was presented, Your Honor. So at the end of the day, if you determine that it's ambiguous, there's no evidence that's going to support a different interpretation than the one that the trial court had here. So at that point, I believe that the court should affirm. To the extent that there is any parole evidence, presumably the trial court was in a better position to determine the credibility of that parole evidence, and ultimately made the determination that that the outcome should be that the plaintiff hadn't met their burden.
How long was the or was it when your client started producing, or when actually had them produce the product for the United States? How long was that manufacturing and licensing arrangement in place? Like a year and a half, something like that?
I think it was 2012 to the end of 2015. And to be clear, it was very slow at the beginning. It was a startup company. It was ramping up through 14 and then ended at the end of 2015 is when Yowie discontinued making any further orders from Whetstone.
What does the record tell us about whether Section 4 or Section 5 were applying for each of those years? In other words, was it the understanding of the parties that this is an exclusive year for 2013 and 2014, but then became a non-exclusive?
Every year that Yowie paid the fee, they paid the exclusive fee. So through the way that the minimum fee works is you paid it at the beginning of the year. It was sort of like a prepayment for the exclusive rights for the year that was to follow, which makes sense. So the parties knew what their rights were. Did they have an exclusive right this year or a non-exclusive right? Yowie, every year that it made that payment, it made it at the exclusive level. Okay, well, that raises an issue for me, because in that case, your client basically paid the fees for 2013, 2014. I think maybe they were renegotiated in some way. But then the next year, the fees would have gone up dramatically. They would have doubled and tripled and so forth. So that's when they decided not to play ball anymore. Well, I mean, Your Honor, the record is fairly replete with all of the reasons that Yowie determined it no longer had a business partner that it could work with respect to Whetstone. But from a legal perspective, that is correct. The fees were set to go dramatically up. Yowie made a business decision that it couldn't. There's testimony that they felt that if they stayed in the relationship, they would go bankrupt. And so made the decision that they found an alternative shell design and found a different manufacturer and stopped using his patent moving forward. With the reason the fee amount under Section 4 go up so dramatically and stay there for a number of years, that's because that was the life of the patent that was left, correct? In other words, the patent was still in play at that point, Your Honor. I'm not sure if or where this is in the record, but I think it's fair to say that there was an understanding that things would start slow because this was a startup company. And as sales and momentum went, that there was the hope and belief that Yowie would be selling many more of these, and so the minimum payment that was due would sort of match what the fervency of sales from the company. So let's assume the relationship was hunky-dory, going along well, making money, and then we come to 2020. In 2020, the minimum fee for exclusivity under the patent isn't there anymore. And instead, what would happen is for the next, until 2027, for the next 8 years, it would just be governed by that 5%. I think it was something along those lines, or whatever was amended to. Correct. Okay, so these fees, minimum fees, were only for the period during which the licensing of the intellectual property would be in play. Yeah, I think the reality between the partners between the companies is that they realized the patent expired in 2019, so he couldn't offer an exclusive relationship anymore. Anybody was free to use the shell, but there still was contractual terms set forward if the parties continued with the manufacturing relationship and with Mr. Whetstone's technology used in the manufacturing process. So that's
So,
why
counsel,
the exclusivity dropped off.
let me just make sure I understand that part correctly. So so that patents expire in 2019, had Yowie continued making orders and things had continued into 2020 and beyond, would what you're saying is Whetstone could not have offered an exclusive relationship anymore because just anybody could pick it up at that point, correct?
Correct. The patent
Yes.
expired.
Now, when somebody else picked it up, let's just say, ABC company, whatever, right? They say, hey, we're in the business now, and we're going to use these expired patents. We're going to use that process, and we're going to create these products. They wouldn't have to pay Whetstone anything, correct?
Correct. He doesn't have the patents expired. He no longer is entitled to royalty payment.
ABC company wouldn't owe Whetstone a dime.
Correct.
But Yowie would.
Correct.
Okay.
I mean, there is a relationship between the two contracts.
Counsel, there's nothing wrong with that. That's a perfectly legal relationship. Your client agreed to it. Couldn't it well be that the fee amount was set slightly lower for the first 6 or 7 years, the expectation that Whetstone would recover between then and 2027 when it was not exclusive and was not patented anymore?
There's no evidence of the record to support that, but that certainly could be possible, Your Honor.
Okay, right. I mean, it's a possibility, right? There's nothing illegal about the contract. There's nothing you'd agree, wouldn't you?
It's beyond the scope of this argument, but there is federal case law that says that contracts that seek to have royalty payments past the expiration of a patent are unenforceable. Not why we're here. And
so let me short circuit this. I wasn't suggesting that there was anything amiss about that provision at all. I think what I was trying to suggest is that it seems like that might be consideration on Yowie's part.
Certainly, Yowie was agreeing to do something that had it not had a relationship with Whetstone, it would have been in the same position as ABC Corporation.
It otherwise, as of 2020, could have used the patents and paid nothing.
Correct. And in that sense, Yowie was at a detriment to ABC Corporation because it was paying royalty. Judge, that sort of leads me into the consideration issue. I do think that there's another point with respect to consideration that we need to think about. And that's that consideration, typically the case law is that you don't just look at isolated provisions of the contract and decide whether there's consideration for just that little provision of the contract. I agree with counsel in the sense that you do need to look at the contract as a whole in an interpretation. To suggest that there wasn't consideration in this contract is belied by the record. Mr. Whetstone was making hundreds of thousands of dollars a year in royalty payments under the patent agreement. And so he was definitely receiving something. Yowie, of course, was receiving something as well, which was for the period of time that it was working with Mr. Whetstone, it was receiving the exclusive use of his patent, and no one else in the industry could come in and also use that same shell technology. So the parties, there was a bargain for exchange here to try to, narrow it down and just say this option, it was one-sided, which we agree with, we disagree with. It was not one-sided. Both parties got something no matter what selection they made, and both parties were giving up something no matter what selection was being made. So we disagree that there was not consideration, given that, this was a contract, it was negotiated at arm's length. Maybe Mr. Whetstone doesn't like the consideration that he ultimately got here, but that was subject to the negotiations of the parties back when they formed this contract. The other issue that has been raised by the plaintiff in their appeal is the argument that the agreement was terminated, and you briefly addressed that in some of your questions, but I want to pick up where you were discussing that. We take the position that the record is clear that neither one of these contracts, and we're talking about the patent agreement right now, but neither one of the contracts were terminated. And to support that position, I'm going to actually cite to the plaintiff's brief on page 28 and 29. They cite to the Florida recycling case, and that case stands for the proposition that when a contract has a provision that says that any termination has to be in writing, the trial court said that there was substantial compliance with that provision, even though the termination wasn't in writing. And the Court of Appeals said, no, we're going to enforce that agreement as written, and any termination has to be in writing. I defy anyone to point to us anywhere where there is a written termination of this agreement by Yowie. The only things that have been pointed to by the plaintiff are Loxton's testimony at trial, where he, if you look at the totality of his testimony, he made clear that the manufacturing agreement was never terminated. And he said, as to the patent agreement, we made the decision not to pay the either exclusive or non-exclusive fees. So the relationship ended, but there was never any written termination that was sent to Whetstone, nor did Whetstone ever send any written termination to Yowie. The only written document that is in the record that was cited to by the plaintiff was a December 7th, 2015 letter, Exhibit 331, from counsel. That was the letter that essentially notified them of the relationship ending, but it never stated that the relationship or that the contracts were terminated. In fact, what it said was that the two presidents of the companies are currently under negotiation. The hopes being that they can come up with some sort of settlement that ultimately will resolve the case and terminate the relationship between them. Thus, the letter made clear that the relationship and the contracts weren't terminated at that moment. So there's nothing in the record that supports that the contract was ever terminated. In fact, the way that the contract is written, we believe that we could call Yowie today, or sorry, call Whetstone today and say, here's our forecast for 2026. We'd like to start using your patent and start manufacturing. Let's move back forward with the contract, because the contract itself has never been terminated per the terms of the contract itself. So there's no such thing in Florida law as an effective termination or a substantial termination. A contract is either terminated or it's not. When a contract has a specific way in which it is terminated, in this case, has to be a written notice, then that has to be followed. And there's just nothing in the record to support that there was any written notification given from either party, from either Whetstone or from Yowie. Your Honor, with that, if the court has any further question on the patent agreement, I'd move on to the manufacturing agreement, which I don't believe we've had a chance to speak to yet.
Counsel, just so you know, you're getting close to your rebuttal time, but I'm just pointing that out.
So the 5 minutes on there is what I have in total left?
I believe that's correct.
Okay, then, Your Honor, I'll go ahead and rest at this point and reserve the balance of my time.
Marshall, I don't know if the marshal can signal to us whether that's correct or not, but I think that's correct.
That is correct, Your Honor.
All right, thank you.
I'd like to start by focusing on the language at the end of Section 5 of the license agreement. There's quite a lot of discussion about that. And I'd like to address Judge Eisnagel's interpretation and take it to the next extension. So the way I understand your interpretation, Judge, is that what Yowie gave up is the right to produce the product. That's how I understood how you're interpreting it. But if that's true, that Yowie gave up that right, then they breached that provision by continuing to manufacture products. They have continued to manufacture 2016, 2017, 2018, and onwards.
They're using the Whetstone patent in 2018, 2019?
No, and that's my point, that Section 5, that's only talking about if they're using the patent. So they haven't given up any separate right. They haven't given up some right to produce the product in total. So what have they given up? In nothing. All they've given up is whether or not to exercise that option. And that's not something they had to begin with. That is something that Mr. Whetstone's given them in this contract.
Counsel, if they want to exercise that option today, they would have to pay the Section 1 royalty fee. No one else has to pay that. No one else has to pay that.
That is consideration.
Hold on, counsel, wait. No one else has to pay that, correct?
Correct.
Okay. How is that not giving something up?
That is giving something up for the right to use the patents. So for the right to use the license. But I think what the Polk case I cited tells us is that you have separate consideration for the underlying contract, here the right to use the patent, and for the option. There it was separate.
Oh, you're trying to, hold on. So instead of reading the contracts together, you're trying to separate Section 5 out and isolate it?
I'm saying that it's Section 5, under the trial court's interpretation, I don't read it this way. But under the trial court's interpretation, it's an option, right? That's what the court said. And what the case law tells us is that if you have an option, it needs to have consideration separate from the underlying right you get from the option. So, for example, with a real estate contract, you pay rent for the house. That's your consideration to live there. But if you have an option to rent the property for so much money and you want to keep that option open, make it irrevocable, that option needs to have separate consideration. That's what the Polk case says.
So, but look, so the answer is yes. You're saying don't read section 5 with the whole contract. We should just look at section 5 and decide if there's consideration for section 5.
Yeah, yes, the last part that you said is correct. There does need to be separate consideration for the option, and that's the Polk case cited in my brief.
Counsel, quick question. The verdict following non-jury trial, the document that the trial judge signed off on, I saw that there were proposed orders put in by both sides. Was this sort of the ultimate order that Judge Maltz entered? Was it one order or the other, or was it a conglomeration of the two, or his own independent work?
So I believe he kind of wrote his own. I haven't parsed through it to see what exactly he took, because the proposed orders aren't in the record.
That's fine. Thank you.
I do agree with how Judge Makar reads that language at the end of section 5. It's just a remedies clause. It doesn't say Mr. Whetstone's limited to terminating the agreement. And for a case on point there is the Indian River case cited on page 28 of my brief, dealt with a similar situation. I see my time's up, so unless this court has any questions, I'll rest on my briefs.
Great, thank you. Okay, Mr. Dickinson, I believe you have approximately 5 minutes or so. Now, keep in mind, this is on the cross appeal only. So we're not going to the main appeal. Okay.
Your Honor, with respect to the cross appeal, the trial court entered a small verdict for the plaintiff on 2 allegedly unpaid invoices that are set forth in the brief. And they both relate, one relates to EBITDA, and one relates to what the parties refer to as a square up for fixed costs that they would do at the end of the year. I believe that the trial court made 2 errors with respect to these 2 invoices. One, it seems if you look at the court's verdict that they inappropriately, did we lose a judge?
Yeah, we did.
Yes, Your Honor, let me check on that.
I was worried my internet connection was going to go out. But okay. Mr. Dickinson, where are you located? Are you in
Omaha, Nebraska.
Okay, well, we're sorry to have denied you a trip to Daytona, but
It wouldn't have been the worst trip in the world, Your Honor, but happy to do it by Zoom as well. Actually, our weather's pretty good this time of year up here.
all right.
If this would have been February, I might have insisted a little harder, but as is, it's fine.
All right. Well, hopefully we can get Judge Eisenagel back either via Zoom or via phone. Or if maybe he'll just tell us to conclude and move on, but we'll find out shortly here.
Maybe he really didn't like the cross appeal.
Suspicious timing for certain.
Why don't we do this? We're in the cross appeal, and we're down to the last 4 minutes or so, and we hope Judge Eisenagel will become a part of this. But I think let's take I'm going to say let's keep moving forward, and if he joins us, great. If he doesn't, then he can watch the remaining 4.5 minutes.
I'm fine with that, Your Honor. Is the marshal ready to start the clock?
Yes, sir, I am.
All right, thank you. So the first issue we see with respect to the cross appeal relates to what seems to be from the judge a burden shift. our view is that the burden at all times on this issue rested with the plaintiff, in that a breach of the agreement is one of their elements. And the breach that they're claiming here is that we didn't make a payment on either one of these. We believe that we did, and we presented evidence to that. And at all times, this is not an affirmative defense. This is a negating defense to negate their claim. And here, Judge Maltz seemed to suggest that we didn't put on sufficient evidence to demonstrate payment, as opposed to affirmatively stating that they did put on sufficient evidence to demonstrate a lack of payments. And that's significant given the competing evidence here. And here is the evidence. The only evidence of non-payment that they presented was an invoice. And that invoice is a statement of account. It's Exhibit 154, and it's dated February 8th, 2016. Should I keep going, or?
I see Judge Eisnagel is now on the line, connecting to audio. He's back. Please proceed. I think he's back. There, well,
I think,
there he is.
can you hear me?
Barely. Can you hear the audio?
I can hear you, Judge Makar. Can you hear me?
I can.
Okay, I can hear everything just fine. Sorry about that.
No problem. Mr. Dickinson has about 3:22 left.
Thank you. With respect to the evidence that was presented by the plaintiff in support of their position that these these invoices were not paid, they presented a statement of account that said they haven't been paid. And then, of course, Mr. Loxton testified they haven't been paid. That's the totality of the evidence that they put on. In response, we submitted through Mr. Loxton Exhibit 340, which explained how the EBITDA was paid through increased tolling rates for all the products that were sold and that Mr. Whetstone was entitled to his royalty tolling payment for. And then if you added up all the increase in tolling payments, they actually added to the exact amount that Mr. Whetstone said was not paid in EBITDA. The other issue with respect to the square up is that the evidence was clear that Mr. Whetstone was seeking square ups for overhead payments fixed costs with respect to the factory through the end of 2015, when the evidence was clear that all manufacturing ceased at the plant on November 18th, 2015. And in fact, Judge Maltz specifically found that Yowie was not required to pay any fixed costs when there was non-manufacturing period. And so we were asked to pay for an entire year worth of fixed costs, when in fact there's roughly 6 weeks where we were not manufacturing, and that wasn't taken into account by Judge Maltz. We've done some rough math, and we believe that it ultimately zeroes out what they're asking for. So for those reasons, we don't believe that there was competent and substantial evidence to ultimately support Judge Maltz's finding that we in fact didn't pay these two invoices. We believe the competent substantial evidence is that we did in fact pay both of those. And I would also like to cite the court, in addition to Exhibit 340, which is the key exhibit. There were other places where the parties were, both via email and documents, were discussing these particular invoices, and we believe that they clearly show payment. And for the little time I have left, I'll just tell you those exhibits we would request that you look at are Exhibits 53, 173, 182, 193, 338, and 350. We believe all of those exhibits support our position that these two invoices have been paid in full, and more than dwarf the self-serving testimony from Mr. Loxton and the statement on account that asserts that we continue to owe this money. And for those reasons, we believe that portion of Judge Maltz's verdict should be overturned, and the verdict should be completely in the defense's favor. Thank you, Your Honor.
Wonderful. Well, thank you both for your advocacy, and we will be in recess.
Thank you.
Judge Makar, if I just wanted to say that this is not an easy case. It's quite complicated, and both counsel did an excellent job. Thank you.
Thank you.
Thank you, Judge.
All right, we'll be in recess now. Thank you.
Thank you.